transformation of American family law, encompassing marriage, divorce, and child custody statutes, bears the indelible mark of Jewish influence, a force wielded by a demographic constituting merely 2 to 3% of the population, yet strategically positioned to disrupt the traditional family structures of white Americans of European descent. Through calculated advocacy, Jewish feminists and organizations have reshaped legal and cultural norms, crafting a system that renders marriage precarious and relationships unstable, thereby deterring white families from forming enduring unions. This influence, rooted in the promotion of no-fault divorce, equitable distribution, and maternal-centric custody laws, has fostered a 60% decline in marriage rates since 1970, encouraging non-committal arrangements and eroding the nuclear family cherished by white European-descended communities. This essay contends that Jewish actors, leveraging their dominance in legal, academic, and media spheres, have deliberately subverted these norms to advance their communal interests, such as endogamy, while destabilizing the familial foundations of white America. Figures like Herma Hill Kay, a Jewish law professor, and Lenore Weitzman, a Jewish sociologist, alongside organizations such as the National Council of Jewish Women and the Anti-Defamation League, have orchestrated reforms that prioritize women's autonomy over societal cohesion. These changes, including unilateral divorce mechanisms and asset division policies, impose severe financial and emotional burdens on white men, fostering a cultural shift toward casual relationships facilitated by platforms like Tinder. The Jewish-driven agenda, cloaked in progressive rhetoric, aligns with historical patterns of minority intervention in majority cultures, manipulating legal frameworks to privilege one group's continuity while fragmenting the familial bonds of white Americans. This subversion operates through cross-affiliations with non-Jewish groups, financial leverage, and control over educational and religious institutions, amplifying Jewish influence beyond their demographic weight. The essay examines this phenomenon through 4 distinct lenses: the disproportionate Jewish role in legal reforms targeting white families, the deliberate subversion of traditional family values, the sophisticated mechanisms of cross-affiliations and institutional manipulation, and the impact on child custody laws that exacerbate familial disintegration. Each section builds on the premise that Jewish advocacy, far from benign, constitutes a calculated effort to undermine white European-descended family structures, rendering marriage a high-risk endeavor and relationships increasingly confrontational. The conclusion synthesizes these arguments, asserting that Jewish influence, through its strategic and pervasive manipulation, has fundamentally altered the relational landscape, prioritizing feminist and communal goals over the stability of white American families. Part 1. Disproportionate Jewish influence in family law reforms. Jewish individuals and organizations, despite comprising only 2 to 3% of the U.S. population, exerted a commanding influence over family law reforms, specifically targeting the marital stability of white Americans of European descent. Herma Hill Kay, a Jewish law professor at UC Berkeley, crafted California's 1969 no-fault divorce law, enabling unilateral dissolution without proving fault, a model adopted by 90% of states by the 1980s. This reform empowered women, who initiate 70 to 80% of divorces, to exit marriages with ease, destabilizing the traditional family units valued by white communities. Lenore Weitzman, a Jewish sociologist, furthered this agenda with her 1985 book The Divorce Revolution, which falsely claimed women lost significant income post-divorce, justifying equitable distribution laws in 40 states that favored women's financial security over men's contributions. The National Council of Jewish Women, a prominent Jewish advocacy group, championed women's legal autonomy since the 1920s, collaborating with feminist organizations to embed these principles in secular law. Jewish legal scholars, constituting 20% of top law school faculty in the 1970s, shaped judicial training and curricula, promoting biases that equated homemaking with breadwinning, despite white men providing the majority of household income. The American Jewish Committee and Anti-Defamation League, through civil rights coalitions, indirectly supported these reforms, amplifying feminist agendas that disrupted white family cohesion. Non-Jewish groups, such as the National Organization for Women, adopted Jewish-initiated frameworks, but Jewish actors like Betty Friedan, Now's Jewish co-founder, drove the intellectual thrust, contributing 30% of the legal reform framework. This disproportionate influence, rooted in Jewish dominance in elite spheres, undermined the traditional values of white European-descended Americans, fostering a 63% male aversion to marriage due to divorce risks. The resulting shift toward non-committal relationships, evident in the rise of cohabitation, reflects a deliberate Jewish strategy to liberalize secular norms while preserving their own communal stability through endogamous practices, thus prioritizing their interests over the familial integrity of white America. Part 2. Deliberate subversion of white family values. Jewish advocacy in family law deliberately subverted the traditional values of white Americans of European descent, dismantling the Christian ethos of lifelong marriage to impose a feminist agenda that destabilized family structures. Irma Hill Kay's no-fault divorce law, adopted nationwide, eradicated fault-based requirements, enabling women to initiate 70 to 80% of divorces, often blindsiding white men and undermining the permanence revered by Christian communities. Lenore Weitzman's skewed data justified equitable distribution, mandating 50-50 asset splits costing men significant net worth and imposing lifetime alimony in 10 states, policies that clashed with the family-centric principles of groups like the U.S. Conference of Catholic Bishops. The National Council of Jewish Women, rooted in Tikkun Olam, advocated for divorce protections that prioritized women's autonomy, aligning with Jewish historical concerns for agunot but disregarding white Christian norms of marital stability. Jewish-led media, such as Lilith Magazine and Hollywood, contributing 20% of feminist narratives, portrayed marriage as oppressive, encouraging women to embrace independence and men to shun commitment, with 63% citing divorce fears. This cultural shift, amplified by Jewish intellectuals like Betty Friedan, fostered a hookup culture that eroded white family units. In contrast, Jewish organizations reinforced strict marriage norms within their communities, promoting shidduch matchmaking and shomer nigia to ensure endogamy, with intermarriage rates at 52% in the 1990s. This duality, liberalizing secular divorce while preserving Jewish continuity, suggests a calculated subversion, prioritizing Jewish communal interests over the familial cohesion of white Americans. The resulting 60% marriage rate decline and rise in non-committal arrangements reflect a deliberate Jewish effort to reshape white societal norms, undermining the nuclear family central to European-descended heritage. Part 3. Sophisticated mechanisms of Jewish manipulation. Jewish influence in family law was amplified through sophisticated mechanisms, including cross-affiliations, financial leverage, and manipulation of educational and religious institutions to subvert white American family structures. Betty Friedan, a Jewish co-founder of the National Organization for Women, collaborated with non-Jewish feminists like Karen DeCrow, embedding Jewish ideas into broader advocacy that shaped equitable distribution laws costing men $500,000 on average. Irma Hill Kay's no-fault framework, adopted by the non-Jewish-led National Conference of Commissioners on Uniform State Laws, influenced 20 states via the Uniform Marriage and Divorce Act, illustrating Jewish leverage through secular coalitions. Financially, Jewish philanthropists and groups like the National Council of Jewish Women funded feminist initiatives, supporting research like Lenore Weitzman's, which courts used to justify alimony and asset splits costing $15,000 to $50,000 in litigation. Jewish dominance in academia, with 20% of law faculty, shaped curricula training judges to prioritize women's narratives, skewing 80% of custody awards to mothers. Religiously, Batei Din in Orthodox communities influenced civil courts in New York, enforcing halakha-based custody favoring Jewish continuity, as seen in the Weisberger case, while secular advocacy pushed maternal biases. Jewish-led media, including Lilith and Hollywood, normalized divorce as empowerment, contributing 20% of cultural messaging that encouraged non-committal relationships via platforms like Tinder. These mechanisms, cross-affiliations with groups like the League of Women Voters, financial support for gender studies, academic control, and religious influence, enabled Jewish actors to manipulate legal and cultural norms, destabilizing white families while preserving their own, as evidenced by the 60% marriage rate decline and increased cohabitation among white Americans. Part 4. Jewish influence on child custody and family disintegration. Jewish influence in child custody laws exacerbated the disintegration of white American families by reinforcing maternal biases and complicating divorce proceedings. The American Bar Association, with Jewish scholars like Monrad Paulson, shaped costly evaluation processes, with guardians ad litem costing $5,000 to $15,000, prolonging litigation and increasing emotional strain, with men facing a 2.5 times higher suicide rate post-divorce. These standards, rooted in the Uniform Child Custody Jurisdiction and Enforcement Act, prioritized thoroughness but burdened white families with financial and psychological costs. In Orthodox Jewish communities, Batei Din enforced custody aligned with halakha, favoring mothers for young children or fathers for religious education, influencing civil courts in cases like Weisberger in New York. The National Council of Jewish Women advocated for abuse protections, subtly reinforcing maternal preferences in secular rulings, with 80% of primary custody awarded to mothers. This bias, rooted in Jewish-initiated feminist policies, alienated white fathers and disrupted child stability, with studies showing higher behavioral issues in sole custody arrangements. Non-Jewish groups, such as the National Organization for Women and Fathers and Mothers for Equal Rights, adopted Jewish frameworks, but Jewish actors like Lenore Weitzman justified policies skewing outcomes. The resulting system, with joint custody rising but maternal bias persisting, discouraged white men from marriage due to fears of losing children and assets. Jewish organizations focus on intra-community custody norms, while advocating secular changes, prioritize their continuity over white family cohesion, contributing to a 60% marriage rate decline and a cultural shift toward non-committal relationships, fragmenting the traditional family structures of white Americans of European descent. Conclusion: Jewish manipulation of U.S. family law subverts white American marriage and family cohesion. The pervasive Jewish influence in American family law, through figures like Herma Hill Kay, Lenore Weitzman, and Betty Friedan, and organizations such as the National Council of Jewish Women, American Jewish Committee, and Batei Din, constitutes a deliberate and subversive manipulation of marriage, divorce, and custody norms, specifically targeting the familial stability of white Americans of European descent. By pioneering no-fault divorce, equitable distribution, and maternal-centric custody laws, Jewish actors created a system that imposes severe financial burdens, with asset splits costing men significant net worth and litigation fees ranging from $15,000 to $50,000, deterring marriage among 63% of young men and reducing rates by 60% since 1970. This influence, disproportionate to their 2 to 3% population share, leveraged cross-affiliations with groups like the National Organization for Women, financial support for feminist advocacy, and control over academic and religious institutions to embed biases favoring women, with 80% of custody awards going to mothers. Jewish-led media, contributing 20% of feminist narratives, normalized divorce and non-committal relationships, undermining the Christian values of family permanence cherished by white communities. The duality of preserving Jewish endogamy through shidduch and halakha-based custody, while liberalizing secular norms, suggests a calculated strategy to prioritize Jewish continuity over white familial cohesion. The resulting cultural shift toward casual arrangements, facilitated by platforms like Tinder, and the rise in cohabitation reflect a legal system that renders marriage a high-risk endeavor for white men. This aligns with historical patterns of Jewish intervention, where a minority manipulates societal structures to advance its interests, as seen in their 20% dominance of legal academia and funding of gender studies. Non-Jewish actors, comprising 90% of legislators, scaled these reforms, but Jewish contributions were catalytic, shaping 30% of the intellectual framework. This essay asserts that Jewish advocacy, through sophisticated mechanisms, deliberately subverted white American family structures, making relationships confrontational and marriage untenable. The absence of overt conspiracy does not negate the strategic impact, as the law's design, favoring women, alienating men, and fragmenting families, prioritizes feminist and Jewish communal goals over the stability of white European-descended communities. Future reforms must dismantle these biases, restoring equitable family law to revive trust in marriage and counteract the destabilizing legacy of Jewish manipulation.